Hello everybody. So welcome here today to the second annual Ninian Stephen Law Program Oration, hosted by Centre for AI and Digital Ethics and the University of Melbourne. So a quick introduction. My name is not Professor Cheryl Saunders, which is who you might be expecting to see here tonight, who was supposed to host this event, but unfortunately she's come down not feeling well with a throat infection, and so not only does she not want to spread it, she's actually lost her voice, so couldn't do this job tonight. So I'm very privileged to take over here for Cheryl. So my name is Tim Miller. I'm a Professor of Computer Science here at the University of Melbourne, and along with my colleague Professor Jeannie Patterson, who's sitting around somewhere, I'm one of the two co-directors for the Centre for AI and Digital Ethics. So welcome to everyone tonight, in particular some of the special guests we've got here, our speaker who we'll introduce soon, some members of the Menzies Board and the Ninian Stephen Law Program Steering Committee. I'd just like to start off by acknowledging that we're on the traditional lands of the Wurundjeri people. They're the people who traditionally owned this land and still own this land, and their land stretches from probably as far east as Healesville to as far west as Gisborne, and as far north as some of the northern tributaries of the Birrarung River, otherwise known as the Yarra River. We understand the importance of the land to the First Nations people, but I think one of the important things about the land is how it ties into their knowledge systems and how they use it in their knowledge systems. And if you've read anything about Indigenous knowledge systems, you'll know that the land is really tied to the stories. And the stories are really important for passing on knowledge over thousands of years. And when you see these stories, First Nations people didn't have stories about science and philosophy and stories about religion. They just had stories that mixed all these three things together. And that was the way that knowledge was transmitted and thought about. And that's a far cry from the way that we silo knowledge in universities these days, where we have individual buildings that house departments. And the Centre for AI and Digital Ethics is trying to sort of take inspiration from this model of mashing different disciplines together, and we're bringing together lawyers and computer scientists and philosophers and political scientists and artists and musicians all together in one centre. And the Ninian Stephen Law Program is an example of a project that has arisen from this. I'm not going to give a long introduction about Sir Ninian Stephen, but we have a fabulous video on our website where Dr. Ramona Vijeyarasa and myself interviewed Cheryl Saunders, who was Professor Cheryl Saunders, who was due to be the host tonight, who worked very closely with Sir Ninian, and we sort of talked a little bit about the program and asked a lot of questions about Sir Ninian Stephen as a person and as a person to work with. But he was a High Court judge, and he was a Governor General, and if you read a bit about him, you know he was a mentor to many people. And one of the things he was known for was his ability to discuss legal concepts in very non-legal terms to people who aren't specialists in legal aspects. Another thing that's really big for breaking down silos. And I hope that he would find this program that we're doing now in his name a worthy cause. So before we get on to our orator for the evening, I just want to, we're going to give a brief overview of the program and where we're up to. The program started officially just over 15 months ago, but in earnest it started in January when our postdoc, Dr. Ramona Vijeyarasa, started. So I'd like to invite Fahima, she is down here, to give a short overview of the project.
Thank you for the kind introduction, Tim. Hi everyone. Emerging technologies are shaping the way we live today. Many of these changes are great and make our lives easier. However, they often challenge us to change. So are we prepared for what's coming next? A major cybersecurity incident has occurred at Medibank Private just weeks after 1/3 of Australians had their information held to ransom in the Optus data breach. These challenges are changing the relationship between law and technology and continue to raise questions. For example, data protection laws are more focused on the time when data is collected. But what happens after data is obtained? For the legal profession, these digital transformations can also bring unanticipated legal and ethical risk. The Ninian Stephen Law Program, New Legal Thinking for Emerging Technologies, is a 4-year initiative powered by the Menzies Foundation. New Legal Thinking describes the kind of skills that lawyers need to go beyond the analysis of law based on existing legislation and precedent. This project will conduct research to understand these gaps and how we can address these challenges for lawyers in Australia and the Asia Pacific. So, to better understand these challenges and gather richer information, in this project, we are holding a number of emerging tech and law leader forums and seminars to address the current law tech issues, as well as creating a platform for lawyers, academics, students to collaborate effectively. We also conducted a mixed method approach, quantitative and mainly qualitative. We have done a semi-structured in-depth interviews with 25 in-house lawyers, and from them we will survey hundreds more. In this project, we also realized that organizations have insufficient governance and management structures regarding procurement, deployment, design, and development and oversight of emerging technology. In this project, we will also propose the required skills for lawyers, legal professionals, academic students, and even corporate and technology companies to build the best practice capability for addressing the legal and ethical risk of new technologies. And today, over the next 30 minutes, we will be listening to the women's rights activist, Dr. Ramona Vijeyarasa. Ramona is a senior lecturer at University of Technology, Sydney, and the chief investigator behind the Gender Legislative Index, GLI, a tool designed to promote laws that advance women's rights and gender equality. In 2022, her work on the GLI received the Women in Artificial Intelligence Award for the law category and the second runner-up prize for the Woman in AI Innovator of the Year. And that's why, ladies and gentlemen, we have the honor today to have Ramona discussing and highlighting the best practices for harnessing technology to advance gender equality and to ensure that women are at the center of our rapidly digitizing world. So, with all and joy in your heart, please welcome Dr. Ramona Vijeyarasa.
Thank you very much, Dr. Fatima, for those very kind words of introduction. It is wonderful to be here to deliver tonight's oration for the Ninian Stephen Law Program. As already mentioned, Sir Ninian made so many contributions during his lifetime in law, but for me as an international lawyer who's worked in transitional justice, it was particularly his contribution as a judge on the ad hoc tribunals for the former Yugoslavia and Rwanda that I reflected upon when I was given the honour of delivering tonight's oration. It is also very humbling to follow after the inaugural oration of Australia's chief data scientist, Dr. Cathy Foley, and for me really significant that Australia has a woman in such an important role, a point I will return to later. But before anything else, I would also like to pay my respects to the Wurundjeri people of the Kulin Nation, and if I can, the Gadigal people of the Eora Nation, on whose beautiful lands I live and work every day in Sydney. I pay my respect to elders past and present and the Indigenous people here with us today and acknowledge that this land was never ceded. So I'd like to start this oration by taking us back 12 years when I found myself living and working outside of Australia. I was a women's rights lawyer working for ActionAid International. Some of you might have heard of ActionAid. It's an anti-poverty NGO with offices in more or less 50 or so countries around the world. Now, ActionAid was an NGO largely focused on rural poverty, so until then we really focused on the kinds of issues experienced by, for example, women farmers. Well, we just started to turn our attention to urban poverty and the kinds of poverty women were experiencing living in big cities. So I was working for the headquarters in South Africa, but out of their offices in Ghana, in Accra. So that's remote working to its best. And these are some of the photos from my time living in Ghana. Now, Ghana was one of the safest cities in West Africa. Accra has a population of around half that of Melbourne. But without a real CBD and a proper industry, urban poverty was a real reality. Over the years that followed as a women's rights lawyer, I would meet with countless women who would talk to me about their experiences of urban poverty. From the garment workers of Cambodia living in the export processing zones on the outskirts of Phnom Penh, through to young women and girls living in Johannesburg for whom water and electricity cuts was a reality, forcing them to use unlit and unsafe public toilets and public showers. But for me, it was in Brazil that I saw a level of civil society organisation like no other in response to this issue of urban poverty. In the favelas or the slums of Heliópolis, the people were taking back their communities by demanding from the local governments and authorities an investment in industry and housing and education and social services that was completely lacking. But it was particularly the women of Heliópolis who experienced a really significant level of change. After one of the most successful night marches, the government of Heliópolis prioritised the repairing of street lights. These were smart and brave women, and they were taking back and changing their experiences of safety and security. But you may be wondering why I'm talking about this, since I'm here to talk about harnessing technology for gender equality. Well, what I was seeing was the way in which women's rights individuals and groups were starting to use technology to identify their demands and make changes. Some of you may have heard of the Safe Cities apps. Now, at the time, ActionAid was key in campaigning behind these apps back in 2012. And then the United Nations program UN Women also picked up on these apps. Very quickly, women from Delhi, Sydney, London, Istanbul started using these apps to take back their cities and mark unsafe streets, unlit bus shelters, or places where public transport stopped altogether, which obviously affected particular women who needed it the most, such as shift workers. For women vendors in Africa, this technology transformed their capacity, can you still hear me? Transformed their capacity to identify their needs with a simple algorithm that took their answers and translated it onto colour-coded maps. But here comes the twist in the story. You see, these women were marking unsafe places on apps that were public. Those individuals, mostly men, who were targeting women, suddenly knew where to go in terms of the least lit places and the most unsafe streets. Who would be responsible if these apps, created with the best of intentions and helping many, suddenly created new dangers for women? So this was my first foray into women's rights and technology, and I must say it left a little bit of a bittersweet taste. Because even an intervention with the best of intentions, without proper ex-ante analysis and testing, can create a sort of monster. So if I take a step back, I've always wanted to be a lawyer. And I had instilled in me from a very young age to be conscious of those around us with less, particularly from my parents who were migrants from Malaysia to Australia in the 1970s. So for me, law is my natural terrain, but technology certainly isn't. So this new transition has been a bit of a challenge for me. I certainly wouldn't be the only women's rights lawyer who's found herself at this unusual crossroads between law and technology. After all, the language of femtech, for those technology platforms that are creating new enabling opportunities for women's health, only really emerged around 2016. So in the last 6 years, women's rights groups are much more cognizant of what technology can mean for women's health from a privacy perspective, but still, the intersection between women's rights and technology is relatively recent. So fast forward from my decade, living in pretty much every inhabitable continent around the world, I left civil society and returned to my life in academia and joined the University of Technology, Sydney. And I must say I'm very supported by my cohort of socio-legal scholars to put more meaning back into the technology in UTS's name. And as a social justice institution that's very grounded in social justice, this marriage between social justice, technology and law finds a really natural home, even if my journey, as you'll hear, hasn't always been an easy one. As mentioned very kindly in the introduction, earlier this year I was the winner of the Women in AI suppose I'm better described as a woman for AI or a woman using AI. I'm trying to find ways in which law can be used to make gender equality a reality. And I'm looking for innovation and through cross-disciplinarity to find some solutions. So really I'm about what can we use data for its maximum potential, and how do we exploit this potential when data and technology come together. So I want to tell you a little bit about how I became the creator behind the Gender Legislative Index. My journey is really a social justice one, and I want to start at that social justice point, but hopefully we come to this place where we can see how I think technology can be used to we can harness technology for gender equality. But you'll also see some of the challenges that we are up against. So I consider myself an Australian scholar of gender equality. If asked to give an elevator pitch, I would say that my research calls for a gender lens to legislation, looks at what legislators need to make that a reality, identifies the obstacles that we need to overcome, and what would happen if we actually succeeded in overcoming those obstacles. If you were to catch a second lift with me, I would tell you that I created the Gender Legislative Index to measure the gender responsiveness of legislation. It uses human evaluators and machine learning to conduct those evaluations, and data science, particularly data visualization techniques, to display the results in a targeted and I hope user-friendly manner. Now, if that lift were to get stuck, I would be able to tell you why I think Australia can benefit from a gender lens to our legislation and why we need a tool like the Gender Legislative Index. So some of you might have heard of the World Economic Forum's Global Gender Gap Index. It made attention-grabbing headlines with its finding that the world at the current rate of progress in aggregate is over a century away from parity. Now, the World Economic Forum's Global Gender Gap Index ranks countries, and it provides an overall score for each country, but also sub-rankings for educational attainment, political participation, economic empowerment, and women's health and well-being. Now, some of you might be a bit sick of rankings and sub-rankings. I've used up countless academic words to critique indicators, so I understand that perspective, but I also see the value in indicators. So let me cut to the chase. And this might come as a bit of a shock to some who aren't familiar with this. Australia fell from a ranking of 15th in the World Economic Forum's Global Gender Gap Index back in 2006 to 44th in 2020. So that's Laos in 43rd and Australia in 44th. In 2021, Australia disappointingly fell to a rank of 50th between Suriname and the state of Georgia in Central Asia. And this year we had an improvement, a slight improvement, and ranked 43rd between Bulgaria and Suriname. So it may come as no surprise to you that Australia ranks behind Finland, Norway, Sweden, Iceland, the kind of countries we expect to be in the top 4. But Australia's ranking puts us behind New Zealand, who came in at 4th, up from 6th, Albania in 18th, the Philippines in 19th, Burundi in 24th, Mozambique in 34th, and Bulgaria at 43rd. So it's important to be clear on what this measures and means. It is not that a woman in Mozambique is better off than a woman in Australia. This is a measure of comparative inequality. So what it means is that the inequality gap in Australia between a man and woman is bigger than the inequality gap between a Mozambican man and a Mozambican woman. And to me, what's worse is that according to the OECD, the Organisation for Economic Cooperation and Development, has said that Australia is the 10th richest country in the world based on GDP per capita. And yet we rank behind almost all the 30 richest countries in the world, which means Australia fares particularly badly when compared to countries with a relatively similar level of economic development as our own. So as someone who spent so much time overseas working on gender equality, to me it's really important we acknowledge that gender inequality is obviously not a third world problem. It is a global one, and that's so obvious after everything that's happened in Australia over the last couple of years, especially since the Me Too movement. So I've spent time trying to think, well, can the law do better in this fight for gender equality? Can the law play a bigger role rather than just papering over inequality, or sometimes even creating the inequality by embedding discrimination in legislation? But I got to this point where my legal and policy knowledge couldn't take me any further. I needed collaborators, and I needed to look for collaborators outside of the law. And And so this is where my search for collaboration began. And I must say, I knocked on many wrong doors before I arrived at the successful collaborations that I found with Rapido Social in the Faculty of Engineering and Information Technology at UTS and the UTS Connected Intelligence Centre. So Rapido Social is a team of software engineers. They deliver software solutions, like they create bionic limbs, or they build platforms like the Gender Legislative Index. The UTS Connected Intelligence Centre is a team of data analysts and data visualisation experts. And I'm very lucky that they believed in my vision for an index to measure the gender responsiveness of legislation. And so I want to tell you a little bit about the Gender Legislative Index. So the Gender Legislative Index measures domestic legislation against international standards. And one of the great things about using international standards is that every country is measured against the same standard. And they're measured against standards that they've signed up to when they became parties to these treaties many years ago. So if I go to a legislator and I say, well, your laws are performing really badly and these need to be improved, I'm not telling that legislator to do anything other than what their government committed to do many years ago. So there are now laws in the Gender Legislative Index that have been evaluated from Australia, Sri Lanka, Indonesia and the Philippines. And I'm going to talk you through, first of all, how the Gender Legislative Index measures laws, what is the data science component, and most importantly, what can we do with all of this? So the Gender Legislative Index uses human evaluators, and they evaluate a piece of legislation against 7 criteria. These criteria are derived from the Convention on the Elimination of All Forms of Discrimination Against Women, a treaty that Australia signed in 1981. So we've been a party to this treaty now for 4 decades. And it's asking things that seem quite normal and understandable for everyday people. Does the law guarantee access to services that are non-discriminatory and available and acceptable to people? And here you can bring out the experiences of particularly marginalised groups like sexual and gender minorities or culturally and linguistically diverse people. Does the law guarantee non-coerced decision-making and protect women's confidentiality? So, for example, are government agencies in Australia prohibited from releasing a woman's new address to a former or current husband against whom she has a protection order? And currently our laws don't adequately protect for that. Does the law actively promote equality between men and women? Does the law guarantee remedies when things go wrong? And does the law actually require us to collect data so we know whether the law is effective? How do we know our laws are effective if we're not actually collecting data on its implementation? So the Gender Legislative Index uses human evaluators to ask those questions. And they place their answer on a scale from gender regressive right through to gender responsive. And then they give a subjective overall assessment for a law on a scale from complete disregard to international standards through to meeting international standards. Now the index measures laws on a really diverse range of legislation. So there are very gendered issues like family law and gender-based violence and workplace equality. But it also has in there benchmarks, which you can't see on the screen but are publicly available, for mining legislation and taxation and financial services. The kind of laws that rarely ever have a gender lens but that we must bring. But then I arrived at this point and I thought, well, people want a headline story. This is quite hard to process. People want to know, is this a good law or is it a bad law? Which countries do better? Within a country, are there some laws that do really well and some that do really badly? And so I wanted to find a way to provide that headline story. I also wanted to address the fact that there's often disagreement, because getting lawyers to agree isn't always an easy thing. And I didn't want to hide that disagreement. And so this is when my work with the data analyst at the Connected Intelligence Centre began. And this was quite a struggle for us, because really, in some ways, lawyers and data analysts speak different languages. It sounds like a bad joke, a lawyer and a data scientist met in a bar. But jokes aside, I was very lucky to have a data analyst who really wanted to understand my science of law. What makes a law regressive for women? Is gender neutral a good thing, or is it just a cover for a gender blind law? So we had many, many conversations like that one. And then we arrived at 2 solutions. And the first one was to use data visualization techniques like heat mapping to show levels of agreement and disagreement. So on the right at the top, you can see the Gender Legislative Index prototype, and then on the bottom, this is what the Gender Legislative Index looks like today, after we applied user experience to the website. And in the web accessible version of the Gender Legislative Index, you can go deeper. So a policymaker or an academic can drill down to individual evaluations to find out over which provisions was there more agreement and over which was there less, and importantly, why. The second aspect that I suppose really sets the Gender Legislative Index apart is its machine learning algorithm, which uses a series of ordered logical decisions that flow to a final classification. For the tech people in the room, a complex decision tree. So you've got your answer to the 7 criteria that flow to the final result, and the algorithm is actually built on the evaluations provided by the humans in the system. And to me, one of the key aspects of that is that I've tried to remove some of the bias that humans bring to an evaluation. So I'm quite sure that a gender expert evaluates a gender-based violence law more harshly than a tax law or a financial services law. Probably a gender and tax expert would evaluate a tax law harsher. But the algorithm is trained on a subset of data, not knowing which country it is, what year, which person was in power at the time, or what is the subject matter of the law. And so I hope to have arrived at a point where I have a final evaluation underpinned by a bit of integrity. When I got started on the Gender Legislative Index, I placed quite a bit of trust in the data analysts that I worked with. But having come to the tail end of an applied data science program at MIT, I'm quite confident that this was the best solution we had given the nature of the legal problem and the size of the data we were looking at. But I'm also really excited about the potential for the future of the Gender Legislative Index. I would love to have a global database of good practice legislation for legislators to go to who are willing to legislate in a gender responsive way, where they can go and see what's the best practice to legislate to end gender pay gaps or to really promote shared caring through a paid parental leave scheme. And then if you had such a database, what could you do, for example, with natural language processing, just to name an example. So to me, I hope that's the future of the Gender Legislative Index. But you're probably wondering, well, what have I done with this here and now? Where are we at today? And so the first thing I'd say is, I'm often told by people in Australia, surely you don't have discrimination in the law. We don't have that in Australia. That's a problem in countries where, for example, a woman can't get a bank loan without her husband's signature, or a woman can't own property outright in her own name. But to me, the Gender Legislative Index has revealed how much hidden discrimination Australia has in our laws. For example, workplace health and safety acts that don't protect adequately against gender-based violence. Or we have paid parental leave laws that name women as primary carers. There's actually the legislation that does that, undermining shared care. Or we have tax laws that still have dependent spouse tax rebates that encourage women to reduce the hours of work and discriminate against unmarried women. And I want to illustrate this with an example. Apologies, that doesn't show very well. On the right, you have, these are two evaluations of 2 Australian laws. In green, you have an evaluation of Australia's Workplace Gender Equality Act. On the other side, you have an evaluation of Australia's Work Health and Safety Act. So Australia's Workplace Gender Equality Act was an amendment to our Equal Opportunity Act. And as you can see, by all accounts, it's a gender-responsive piece of legislation. It was enacted in 2012, and it's done a really good job at making more evident gender pay gaps in Australia. And it created the Workplace Gender Equality Agency to oversee the implementation of the Act. It is not a perfect law. Culturally and linguistically diverse people don't really find a place in that law, but overall, it's doing pretty well. On the other side, you have the Work Health and Safety Act, which was enacted just 1 year earlier. It creates a duty of diligence to prevent injuries, harms, and illnesses at work. And it defines health to be physical and psychological health. But it does not make any reference to sexual harassment, gender-based violence, or discrimination on the basis of gender at work, despite the impact that would have on someone's physical and psychological health. Nor does it cross-reference to any other Australian laws that do this. So to me, a gender-responsive workplace law has to be more than about spillages on the factory floor, and to provide that comprehensive framework. But what the Gender Legislative Index has shown is that, in my view, women in Australia find a place in the law when the law is about women or gender equality, and all other laws are treated as subject matter neutral. This is an issue that plagues other areas of law, like commercial law or corruption, or new emerging areas like the regulation of artificial intelligence, which are too often treated as subject matter neutral. From a data science perspective, I will say one more thing about the Gender Legislative Index that you can see in this image. It's really obvious from the Workplace Gender Equality Act that there was complete consensus from the human evaluators. And it's quite obvious that there wasn't as much consensus in the harsher evaluation of the Workplace Health and Safety Act. Not only is that really transparent, you can also see the correlations between the human evaluations and the final evaluation at the top by the machine learning algorithm. So I hope there's a visual kind of algorithmic transparency that this allows. And if there's an error in the system, that would also become quite apparent and the algorithm can be corrected. The Gender Legislative Index has also received considerable airtime in the Tasmanian Legislative Council. So independent Member of Parliament Ruth Forrest heard about my research and she used the Gender Legislative Index and my work to push a motion forward that was successful, calling for a joint sessional Gender and Equality Audit Committee, effectively a parliamentary committee to audit legislation. There is no other gender audit committee in any other state in Australia. The ACT has an economic equality and economy and gender audit committee, but no other standalone gender audit committee exists. We don't have one at the federal level, so this is really groundbreaking. And Ruth Forrest used my research to call for Australian laws to remove gender stereotypes. I'm appearing in a hearing before the committee next week to talk to them about the use of these tools as an audit process. So I think this is an exciting place for the Gender Legislative Index right now. Which leads me to another point. We can use technology as academics and it brings integrity to our work, but it can also get your foot in the door. A nice, usable, friendly interface is much more appealing, unfortunately, than a 400-page report, even if the underlying data and research is exactly the same. So I could talk quite endlessly about the Gender Legislative Index and gender-responsive lawmaking in Australia, and I hope there's an interest to do that in this audience here. But you might imagine that I've naturally come to bring together my research on gender-responsive lawmaking with the reality that in Australia and elsewhere in the world, we're starting to talk about how to regulate artificial intelligence. So to me, this brings me back to my earlier story about how technology sometimes creates more problems than solutions for certain groups of people like women. I feel it's important to use my place to call for women to have a place in debates about the legal and ethical implications of the use of AI. But I don't want to dwell on the negative stories because I imagine many people in this room know this well. The way in which algorithms magnify existing inequalities. So for example, they might prevent a single head of household female from getting a bank loan, or where search engines produce fewer results of high-paid jobs when the user enters female and not male. For me, my work as a reproductive rights advocate in the United States has found a sort of disappointing intersection with artificial intelligence after the Dobbs v. Jackson decision that overturned Roe v. Wade in the US, with authorities using data and these apps to track down women who've had an abortion. Now, I don't want to simplify what's going on in these cases. These are very complex cases of both physical and technological harm. But sending a message to users of these apps, young users of these apps, to delete your data and remove your app is hardly going to instill confidence that technology can be a tool for gender equality. But as I said, I don't want to dwell on these problems. I think they're very real and we need to have these conversations, especially for a country like Australia that doesn't have a human rights framework federally to protect these rights. But that is a conversation for another day. Instead, I want to talk a little bit more about what it's meant to be a woman in data science, particularly for a woman from an entirely different discipline. We know artificial intelligence, tech, mathematics, science, these are growth sectors. So we do need to have conversations about women's space in these sectors. So when I created the Gender Legislative Index, I worked primarily with women software engineers and a woman project manager. But right now, most of my collaborators are men. Some of you might have heard of DALL-E, obviously Salvador Dali, but also DALL-E, the web interface that uses artificial intelligence to generate pictures based on a search using natural language. So this was the result of my search in DALL-E for people in data science. Now, there's a massive gap between the number of women in data science, both in education and in industry. So I can't help but think that DALL-E might have gotten this one wrong. Some of you might be familiar with the Stanford University's Human-Centered Artificial Intelligence Index. It's a massive compendium of data that they release every year. And the last index came out in March of this year, around International Women's Day. And that index included a set of data from the Computing Research Association. And the Computing Research Association drew data from around 200 universities in North America. So this is North American data. And among those 200 universities, they found that in 2020, there were 31,000 graduates with an undergraduate degree in computing science. That was an 11.6% increase from 2019. So this is a massive growth sector, and women need to find a place in it. Also, according to the Computing Research Association's 200 University study, of all new graduates with PhDs in computing science and AI, only 20% were women. And that was the same figure from the year earlier. So things are not getting worse, but they're certainly not getting better. This is further data from the World Economic Forum, which shows that on average, the workforce of AI is made up of around 20% women. In Australia, at one point it reached 24%, but that's still only 1 woman for every 3 men. So I think we need to learn from countries that are doing better and figure out how. In Central Asia, Latin America and the Caribbean, they have reached a rate of women in research and development far higher than other parts of the world. So in Central Asia, Latin America and Caribbean, the percentage of female employees in research and development has reached 45%. That's compared to about a third of R&D employees in North America and Europe. In North Azerbaijan and in Macedonia, they've reached a rate of 60% of employees, female employees in research and development. Now, these aren't the kind of countries that Australia would naturally turn to learn from. But I know from my research on the Gender Legislative Index, which study laws from Indonesia, Sri Lanka and the Philippines, good practice may exist in the least likely places, and we need to open our minds to learn from them. We can also learn from countries that have increased the number of women in research and development at a much faster rate in a short period of time. So South Korea went from 10 to 19% since 2000. Morocco also went from 29 to 36%. So if we learn from these countries, we need to educate early, use quotas, stop women leaking out of the pipeline, and use ways to change the image of these sectors. My 6-year-old daughter does a coding club after school each week. Thanks to my applied data science program from MIT, I can actually start to understand the code that she's using. And my 8-year-old last year used Scratch to create a video game. So things aren't changing. We need more women in AI. We need more women in other disciplines understanding what AI can mean. So for those women here in the AI data science tech space, well done for levelling the playing field. And may you also bring other women up the ladder as you succeed. I'm not sure what my children will want to do in the future, but if it is in the women and tech, if it is in the tech and data space, I hope it's very welcoming for them and that they bring that necessary diversity to that space. But I will finish by returning my thoughts to the women who around 12 years ago used technology to show us that an unlit street might be felt differently by a woman or a sexual and gender minority than it would be by a man. We need a gender lens everywhere. And in artificial intelligence, we might be able to get this right from the beginning. It will require participation, advocacy, research, and regulation. But more than anything, I think it requires this consciousness of the differences between how men and women are going to experience AI, and the positives AI can offer to women, but also the challenges. So I hope conversations like this help to create that future. Thank you very much again for hearing my thoughts.
Thank you. That was, thank you for a wonderful talk. A perfect example again of disciplines colliding and breaking down the silos, and in particular for encouraging my 9-year-old Imogen to continue her Scratch programming that she does at home. So we're opening the floor to questions now. There's quite a number of people also at home, but we'll probably prioritise people that are here. But if you have a question, then Abby and Gabby are running around with microphones here, and they'll pass around. So if you have a question, just please raise your hand.
Hello. Thank you very much for that presentation. I'm Sally Mayo from the Faculty of Engineering and IT here at the University of Melbourne. I'm not sure whether I've misunderstood, and perhaps this is more a question about clarification, but is there any chance that you have increased the trust in an instrument by introducing data science and therefore perhaps some kind of system for reducing the bias because we're using data science, when in fact, rather than using a diverse array of evaluators from tax law, gender law and so on, it might have been better to use gender law experts or gender experts to do these evaluations.
Thanks, Sally. That's a great question. The Gender Legislative Index in its current data set relies on gender experts alone at the moment. I would imagine, however, that it would be great to get in the room a diversity of experts, not just gender experts who bring that gender lens, but really a diversity in every sense. Men and then women, diversity across sectors, diversity of ages. And I think that's what would be great to grow the data set. The Gender Legislative Index has undergone 2 evaluations already, and we revised the machine learning algorithm. But really, to really evaluate its capacity in the future, I think it's about expanding the data set and evaluators. But just to clarify, it does use gender experts at the moment. It also uses a set of benchmarks from international law. So the human evaluators don't go in and blindly say, well, this is how a woman is likely to experience this law in reality. The benchmarks allow us to understand, well, what does a service look like when it comes to the workplace? Or what does equality look like when it comes to a mining legislation or a financial services legislation or a tax legislation? So the benchmarks guide the evaluators to make a really informed decision. But I would say that in and of itself is an interesting process, because a lot of us in the women's rights space, if we take data science out of it, focus on a very small subset of issues for which we advocate for change. You know, many in the room would be familiar with debates around coercive control or reproductive rights. These are the kind of issues we typically put in the women's issue basket. So when it came to creating the Gender Legislative Index and developing those benchmarks from international law, there are barely any benchmarks on what a gender perspective looks like to tax. Similar with mining, this is complicated because you have big mining, female mining giants who own mining companies. You have women who are trying to get mining licenses. You have women living in communities that are affected by mining. And you have artisanal and small-scale miners. And that's an important income earner for women. So to further extrapolate on your question, it's also a reminder of how few gender experts there are and how little understanding there is of what a gender lens looks like for a really diverse set of laws. So I think there's so much work to be done in multiple places. Thank you, Sally.
Ramona, how do you see gender inequality?
Can you hear me now? Yeah, okay. How do you see gender inequality how is it related to general social inequality, or what we might call class inequality? Because if you look at the top of the echelon, the richest people like Elon Musk and Bill Gates and Jeff Bezos are all obviously males. Gina Reinhardt is a very rich female billionaire. And so do we need to, it seemed to me, we need to deal with class inequality at the same time as gender inequality, along with other forms of inequality, racial, ethnic inequality. So what are your thoughts along those lines?
I think it's a really great question and a really valid point. So one of the exciting things about measuring the effectiveness of legislation against international standards is those international standards speak to something called intersectional discrimination. So it acknowledges the fact that it's not just a woman who experiences marginalisation or inequality, but that a woman of colour or a disabled woman of colour who's from a sexual or gender minority is going to suffer more exclusion than another woman. And so I very much agree with your point that we need to be talking about multiple types of inequality, and that's why the questions that the criteria applies in assessing legislation allow us to do that. So for example, one of the criteria legislators need to consider about a law is, does that law guarantee access to services? And the kinds of barriers to access services will be different for a woman who's a white woman than it will be for a woman who's a woman living with a disability, than it might be for a woman who's a sexual and gender minority. And so you can add those levels of inequality and those multiple identities to the evaluation. And it's a really interesting question from a legal perspective, because law struggles to deal with intersectional discrimination. We just don't know how to incorporate that into legislation. And so it's quite relevant actually that one of the best examples of a country that's been able to look at discrimination and multiple identities at the same time is Canada, which is one of the only countries that I think has done a good job so far of regulating artificial intelligence. And so Canada has a law on artificial intelligence that talks about biased output. And it talks about biased output in two ways: the way in which output might discriminate and disadvantage certain groups, and the way output might actually advantage certain groups, and it allows for that. But in Canadian jurisprudence, they've actually got case law that talks about your very point, which is intersectional discrimination. And it's one of the few countries that has a really strong jurisprudence to talk about the way in which legislation needs to understand that discrimination will be felt differently depending on one's multiple identities. So I hope that in applying a human rights-based approach to how we do this, that natural perspective of not putting people into singular categories gets to come out. So I think it's a really important one.
Thank you. That was such a good oration. Thanks. That was great. I work in a my mic is coming on and off, but I used to be a lawyer. So I've had a really interesting experience during that talk where I guess in the startup world there's a lot of distrust of regulators and of these kinds of laws, particularly in Australia, where the government has historically introduced laws that have damaged the tech industry. So we saw recently, in the last few years, the last government introduced a law that introduced a back end to technology here, so that we would have to introduce a weakness into data encryption. This might be completely outside of the work that you do, but does that ever come into your consideration, how we can build laws that people who work in AI and tech can trust and can implement easily?
I suppose as a lawyer, I think we probably aren't, as a lawyer, we probably aren't educated enough to think about mistrust in society. So you go through law school and you do law because you're a believer in the law. And if you weren't at the start, you believe in it at the end. And you might be skeptical about its potential and its effectiveness. But if you end up practicing law, we stop realising how skeptical people in society can be about legislation and legislators and its intention and its effectiveness, particularly its effectiveness in bringing about change. I suppose in the data sense, the way in which I grappled with your question, which I think is a really important one, and it is beyond the scope of my work, is ensuring that however we regulate AI, we don't suppress innovation and that we don't misuse the data, and have a sense that it's about collecting data for the wrong purposes as opposed to the right ones. So the article I mentioned up there before, which is published in the Nordic Journal of Human Rights, of International Law and Human Rights, really looks at the sorts of questions we might want to think about, we, Australia, when we create our regulation of AI. And part of that is thinking about how do we find the right balance between not suppressing innovation and tech startups and that potential while protecting against the real harms, because these are real harms. And I think it's a responsibility of our society to regulate, because there are very legitimate harms and concerns. And it's very unknown. So I've taken quite a journey here, but I would have been someone years ago who wouldn't have understood AI at all. And I think that's the vast majority of people who find this very complicated and difficult to understand. It's very hard for people to know how algorithmic bias is generated and how that feeds upon itself and the feedback loops. We understand generally that that exists, but how that happens is difficult. And so if there's a mistrust in law, there's also a mistrust in AI. And so maybe it's about bringing that together to develop a trust that this time round, law can help us bring a bit more transparency and visibility to that without suppressing the innovation that has to happen. And I suppose that's the hardest part as a government in this space. You need to make sure you support innovation at this moment in the world, but also really recognise those harms. And I think some of these harms are very grave, that really has to happen soon.
Hello, Liz from Menzies Foundation. Liz from Menzies Foundation. The reason the Menzies Foundation is so interested in this space is because of the relationship between different ways of thinking about how to solve problems and how to build a space where people, extraordinary talk tonight, where you've managed to navigate both the law and work you're doing at MIT and other ways, just in general, and the power of it, I think, has been very evident in the work that you're doing and the importance of that work. But it's deeply rooted in your capacity to traverse different worlds and to find, as I said, the place in between. And I'm just wondering, generally, my sense is that the law, there is an increasing requirement for lawyers to be more open to building out that skill set that allows them to perhaps have a different level of understanding about the challenges and the questions that they're being asked to address as we navigate an AI world. Have you got any thoughts? What was your disposition to do that? It's interesting for me, you had a struggle to find people in sort of other parts of your work to connect with that. What do we do to break down that silo, do you think? How do we build more opportunities for lawyers to do exactly what you've done and step into a world where they have an expectation on themselves that they'll be more grounded in data and ethics and coding and algorithms and these sorts of things?
I suppose I'd give two answers, and the one goes back to my recommendation earlier. This is a really great question, Liz, so thank you for asking it, which is to educate early. Someone said to me the other day, who was an engineer, and he's a 29-year-old who's looking for a new job. And he said to me when we were talking about quotas, well, you can't force people into these sectors. And I said, well, of course you can't. And I was always one of those people who wanted to be a lawyer. This was really decided for me myself very early on. But I didn't even have the exposure to understand the other possibilities. And so for me, even if people have a decided discipline in mind, educating us throughout that process on those other disciplines and how those intersections looks is really important. A 5 or 6-year-old needs to be exposed to these multiplicity of disciplines so that when they get close to 18, 19 and picking a degree, they understand the world beyond their singular discipline. I think the way in which we structure universities and structure our degrees in very singular ways is problematic in that sense. And I think that's what's so exciting about what's happening at the University of Melbourne, because it's forcing people to think outside the box. But perhaps if we educated differently earlier, without these silos, really early, when we got to university, it wouldn't be such a struggle. I think we also need to challenge legal educators to teach differently. We had a UTS alumni come to an event. He did our JD program and he said, when I graduated from my degree, there was no cryptocurrency and Australia hadn't enacted the Same-Sex Marriage Act. And he said, right now I'm dealing with a divorce between a same-sex male couple whose largest asset that needs to be divided is cryptocurrency. So there's new challenges that even us as legal educators just can't be aware of. We don't know what's around the corner. But creating a thirst for knowledge, creating a consciousness that the world around us is changing, and inviting conversations like this one, where you have multiple disciplines who are forced into speaking other languages, I think is another way to go about it. And it does require a certain type of thinking. I have to say again, I thank the data analyst who worked with me, because he didn't want to just work with me to create an algorithm that worked in his mind. He really did want to understand, what is gender regressive for a woman? Why is this a bad thing? And why I have an issue with gender neutral law, because they're not actually neutral, they're gender blind. And so it's time as well. I've taken a lot of time to get here, and he took a lot of time as well. Thanks, Liz.
Hi, thank you so much, sorry, over here. Thank you so much for your presentation. I just wanted to ask a little bit more on the point about sort of the human evaluators, and I wanted to ask about how you go about choosing human evaluators, especially in fields where men are overrepresented.
So I wanted human evaluators with a legal degree. That was quite important to me that they understood the law. I think it's an interesting exercise, if I can just divert and come back to your question. I'm part of a project run out of Monash University, and we're rewriting legislation from a feminist perspective. And there's going to be a book that comes out, and the first chapter will be, after the Orator statement, a rewriting of the Australian Constitution. Now, for this book, I rewrote the Modern Slavery Act. I've worked on modern slavery for years. In my case, trafficking more than modern slavery, but I've moved into this modern slavery framework. And to rewrite workable legislation is extremely difficult. And I worked with Parliamentary Council to ensure that the law that I was proposing, the bill I was proposing, would actually pass, as the government's about to review this piece of legislation. And And so I think reviewing legislation does require legal expertise. I've had people from other countries say, can I use it? I don't have legal expertise, but can I use the index? And I think that's not really possible. I had an all-female team, and I think it would be great to have men and women in the room. And I also deliberately got people from different legal backgrounds. So there was a French person from a civil law background, civil law trained, and common law trained people. And so it's a different meeting of the minds. But I can give you an example of why you need a diversity of evaluators. In the Philippines, they enacted a law to prohibit marketing of breastfeeding in hospitals, formula to replace breastfeeding in hospitals. So around the time, the WHO had also issued a directive against marketing of formula, because in certain countries, the marketing was so extreme that women weren't really supported to breastfeed. Now, I had two human evaluators with me evaluating this particular law, and one was a very young woman and one was an older woman who'd had children. One woman thought this was a terrible thing and was biased against women who couldn't breastfeed, and it was really challenging women who would want to use formula. And the other woman thought it was terrific. And they both had very different life experiences at that point in time, and that shaped their evaluation. So there's a minimum number of evaluators that you need in a room to sort of get that diversity of experience. And it's not necessarily predictable diversity, but I think racial diversity and gender diversity and age diversity, as well as legal training as a diversity issue, is also really important. But you particularly asked a question around areas that are male dominated. And I go back to my earlier call, which is more work needs to be done to understand how different areas of law are going to affect men and women and non-binary people in different ways. We just don't do this enough. Law is created that you have one law for everybody, regardless of race, age, colour, gender. But the implications will be different. And I think we need to have more of that conversation for these evaluations to be richer and more reflective of the way different people are going to experience legislation.
Hi, thank you for the talk. I just had a question also to do with the legislative index. What's the interaction with, I guess, case law and judicial interpretation relating to gender issues, and does the tool sort of take into account how these gender or, I guess, unequal laws have been considered judicially, if they have at all? Has that been a factor of consideration at all when you've looked at the laws?
I think you've given me my next GLI part 2. So no, it's focused on the written text. And I suppose one of the reasons why I did that is, for me, it's important to get the language of the law right when it's enacted. A lot of activists, men and women, spend many years advocating for law reform. Because you push through a bill, there's a lot of negotiation, and we get the bill passed and we have the act, and we worry about fixing it later. And so the Gender Legislative Index takes a step back and says, well, how can we get the language of the law right? So it's very focused on the legislative text. The evaluators actually go through a two-part process, which I didn't explain earlier, and they look at the text of the law and its actual intention, and they evaluate the actual intention based on the 7 questions, and then they evaluate its likely effect. So for example, a law that creates avenues for a woman to complain about sexual violence, but doesn't actually do anything to address the stigma she's likely to experience going through that process, or protect her confidentiality, means she's not going to use those complaint mechanisms. So it is very focused on the law for particular reasons, but I think it would be great to be able to evaluate case law in this way. There is an excellent project called Feminist Judgments that has evaluated judgments through a feminist lens. I highly recommend you reading some of their work. They've done it in Canada, Australia, and globally. And again, it's very hard to write legally plausible judgments in a case law, set in a particular moment in time, but it has been done.
Hi, could I just ask you, I also wanted to say thanks for your talk, it was really fascinating. I was wondering, while you were talking about the ways of figuring out disparate impact between men and women, if you had a mechanism that you were using for differentiating the sorts of disparate impact which will always be the case, like for instance the fact that women are generally smaller and more vulnerable to violence has an impact on how we experience the world, versus disparate impact which is really due to social factors. So that women are more, likely to give up their jobs for children and things like that. How does that kind of work when you're assessing the legislation?
Well, I suppose it's the reality of how we live, in which the biological and the social intersect. There's other reasons for women to be more prone to gender-based violence, and I'll take your valid point that part of it's biological, but also it's social. It's how people are conditioned, it's how people are supported, whether women are believed or not believed when they complain. And so I wouldn't necessarily separate the social and the biological. What I would say also, to be fair, is that it's not always that women are going to experience the disadvantage and men won't. The areas where men are disproportionately negatively affected by an issue. Interestingly enough, the Tasmanian Legislative Council, quite controversially, has picked as their first gender issue to look at male suicide. We know male suicide rates in Tasmania are very high, they're some of the highest in the world. And so it's another example of a gendered issue that has a disparate impact on men and women in ways that we need to consider as well. So for me, I think you can, however, pick across all the areas that I looked at, so many disparate impacts and all interconnected. So we have gender pay gaps because women don't get superannuation when we're on maternity leave, and women have, because of the gender pay gaps, are more likely to take leave and care after children. So the paid parental leave affects them in a particular way. Dependent spouse tax offsets will also mean that women decide to work less. So the interconnectedness of that picture it's really remarkable when you look at the laws. And so much of it relates to financial and economic security as well, I must say, including escaping violent and unsafe households.
Let's do one last question.
Thanks. Really interested in how governments can use this in policy making and law making, and the Tasmanian example is a great one. But there are built in for many years into standard government processes like cabinet submissions and budget submissions, automatic sort of evaluations that have to be made of consistency with human rights or equal opportunity or environmental impacts, which seem like a really obvious way to hook this in, and clearly in an area where people don't have the tools for making a detailed or a robust analysis, but there is a sort of an expectation that some acknowledgement would be made of those issues. So I wonder whether you've had any engagement with sort of mainstream government processes about how they could do those things better.
I have to a degree, and I suppose my answer would be this. For so long, we've now been talking about gender equality. Australia was one of the first countries to do gender budgeting. And so there is thinking about asking these questions and doing gender audits, but I think we've gotten to a point where it's a bit of a tick box exercise and quite superficial. So the Parliamentary Joint Committee on Human Rights, and I work quite closely with the legal advisor, goes through a process of auditing bills for human rights compliance. And often the end result is a report that comes after the bill has been passed that says there are no human rights implications from this bill, or there are human rights implications but it's justified based on X, Y and Z reason. And so I think it's about asking for a more robust process and trying to build in those kind of questions, because the 7 criteria are systematic questions that you have to ask every time. There's no way to escape that process. So I'm keen to see what Tasmania produces. Will it be a process of going through the motions, or will it really be a model for other states and potentially also the world? Because there are a lot of gender audit committees and there are a lot of standing orders to consider these questions in other countries, Fiji, Finland, the UK, many have these. But again, they often end up being tick box exercises and quite empty. So maybe Australia can be a leader this time when we see what comes out of Tasmania. Something that's rigorous, robust, where there's the expertise to conduct it, there's actual buy-in and a commitment to the process that outlives changes of government as well.
Thank you very much. We'll leave the questions there. I know there's a few people who wanted to ask questions, but I think Dr. Vijeyarasa needs to have a voice break now, so she doesn't end up with Professor Saunders no voice tomorrow. A few things to close. We'll invite you to have drinks and canapes if you can join us afterwards. On the program in the seat in front of you, you'll see 2 QR codes. So, part of the Ninian Stephen Law Program project that we have is precisely about how do we break down these barriers and build skills for lawyers in order to better respond to these things. And if you're interested in getting involved in that by sharing your experiences, for example, an in-house lawyer involved in giving advice on technology, you can scan the left QR code in order to contact us. And if you're interested in learning more, especially if you're a sort of, let's say, early to mid-career researcher who's in the space of giving legal advice around technology, you can scan the second QR code, and we have the Emerging Tech and Law Leaders Forum. So that's the left one, sorry, the Emerging Tech and Law Leaders Forum, where we discuss some of these issues and get some speakers into visits and things. There's a few people quickly to thank. So thank you very much to the Ninian Stephen Law Program and the School of CIS, Computing Information Systems, who funded the event tonight. A big special thanks to Abby Ward and Gabby Bush, who put together all the effort to organise this event tonight. And of course, a very special thanks to the wonderful orator tonight, Dr. Ramona Vijeyarasa, who gave just, I think, a perfect talk that was exactly the type of talk that we want to see at these things. So thank you very much, Dr. Vijeyarasa.